Hey everybody, my name is Blake Thulin, and today we're going to be talking about my brand new book, Abortion Division: Why Americans Disagree on Such a Fundamental Issue of Rights. I'm so excited today. So before we get into it, if you'd like to purchase this, it is out now on paperback and digital, and with a hardcover copy coming soon. You can buy it on Amazon, Barnes & Noble, and everywhere where books are sold. Let's get started. So to really understand Roe versus Wade and the ultimate Dobbs versus Jackson Women's Health Organization cases that were decided by the Supreme Court, it really helps to rewind the clock a little bit and go back and look at one of the first cases that had to do with reproductive rights. And that case is Griswold versus Connecticut. And this was decided by the Supreme Court in 1965. So at this time, Estelle Griswold was the executive director of the Planned Parenthood League of Connecticut. The statute that Estelle Griswold is accused of violating reads as follows. Any person who uses any drug, medicinal article, or instrument for the purposes of preventing conception shall be fined not less than $50 or in prison not less than 60 days, nor more than 1 year, or be fined and imprisoned. Any person who assists, abets, counsels, causes, hires, or commands another to commit any offense may be prosecuted and punished as if he were the principal offender. So, in other words, if you are giving any kind of advice, which would commonly be found in many of today's sex education courses regarding preventing conception, so using condoms, using the timing method even, then you would face prosecution in the state of Connecticut during this time. This was the early 60s. The case was ultimately decided in 1965. So the majority opinion in this particular case was written by Justice William O. Douglas, and he opens up his opinion by stating, "We do not sit as a super legislature to determine the wisdom, need, and propriety of laws that touch economic problems, business affairs, or societal conditions. This law, however, operates directly on an intimate relation of husband and wife and their physician's role in one aspect of that relation." So immediately, Justice William O. Douglas is identifying that there are some limitations to the court's traditional power. And this subject is actually going to come up all throughout not only this case, but also future cases as well, including the Roe versus Wade and the Dobbs versus Jackson Women's Health Organization. And that's ultimately what we're going to be seeing the Supreme Court struggle with internally with itself over the course of the next few decades, going up into the present year. Now, William O. Douglas's most famous quote from this case is actually kind of hilarious. It goes basically along this, that specific guarantees in the Bill of Rights have penumbras, formed by emanations from those guarantees that give them life and substance. Various guarantees create zones of privacy. Now, if you are not a lawyer and you are not an astronomer, you're probably wondering, what the hell is a penumbra? And that is a very reasonable question. A penumbra is basically the space of partial illumination that surrounds a bright object. The Merriam-Webster's dictionary uses an eclipse as an example, or you can also think of maybe stars as having kind of that glowy region around them. But if you are also Justice William O. Douglas, you can say that the Constitution and the Bill of Rights have kind of a glowy section around the Bill of Rights that give life and substance to these additional rights that are not actually explicitly mentioned within the Bill of Rights itself. The funny thing about the Merriam-Webster definition as well is that it states that it is a body of rights held to be guaranteed by the implication in a civil constitution, and I strongly suggest that definition did not exist prior to the Supreme Court decision. William O. Douglas, the justice who's writing the majority opinion here, he goes on to talk about how the First, Third, Fourth, Fifth, and Ninth Amendments have kind of these penumbras, these little extra glowy regions around them that form this right to privacy when you read them all together. So for example, your freedom to practice your religion, your freedom of speech. The Third Amendment prevents soldiers from being quartered in your homes. So that's also, you can see that as a potential privacy issue. The Fourth Amendment with respect to being a prohibition against unreasonable searches and seizures. That can be portrayed as, having a right to privacy or guaranteeing some form of a right to privacy. So These amendments, when you read them together, they seem to imply that there is kind of a zone of privacy that the government cannot intrude upon when it comes to the rights and privacy of individual citizens. So now the argument arises, well, if the framers really truly wanted to have a right to privacy, instead of just mentioning all of these specific rights within the amendments of the Bill of Rights, why didn't they just explicitly state there should be a right to privacy? And this is kind of an interesting point as well, because it really gets into, when we look at the intent of the framers, did they intend to narrowly constrict the interpretation of the Constitution to just the words that they've written, or do they want us to look into their motives and feelings in kind of the overall document in general? So that's going to be something else that we're going to discuss as we continue here. And so Justice William O. Douglas, in his opinion, goes on to say that the Fourth and Fifth Amendments were described in Boyd versus United States as protections against all government invasions of the sanctity of a man's home and the privacies of life. We recently referred in Mapp versus Ohio to the Fourth Amendment as creating a right to privacy no less important than any other right, carefully and particularly reserved to the people. And to really wrap up his arguments and drive home with a very strong emotional point, Justice William O. Douglas finishes off with another quote. Would we allow the police to search the sacred precincts of the marital bedrooms for telltale signs of the use of contraceptives? The very idea is repulsive to the notions of privacy surrounding the marriage relationship. So remember, this case was decided in 1965, where many of the cultural norms were dramatically much more conservative than what we have nowadays. So this idea of the police invading the marital bedroom for the purposes of searching a married couple's property for telltale signs of use of contraceptives was very inflammatory language to be used, especially in this particular context. So this right here kind of just sums up the main point that Justice Douglas is making here, just trying to really drive home that, hey, privacy is an important thing. We are coming in, we're stepping in, and we're saying, no, we cannot have this Connecticut law on the books. We don't want to have police, invading married couples' bedrooms, to see if they've been using contraceptive or if they're trying to control their family size or anything like that. So this is a really powerful point that he's driving home here at the end of his opinion. Now, although this case itself did not have anything really to do directly with the legality of abortion itself, it had a really heavy impact on this right to privacy. And this right to privacy is eventually the vehicle that will be recognized and later used to protect the right to abortion that we see in Roe versus Wade. So this particular right to privacy ends up being recognized through something called substantive due process. Now, substantive due process is a very complicated legal theory that we will get into a little bit later here, but there's also an alternative legal theory as well that we need to take a look at, and that has its origins in the Ninth Amendment. So the Ninth Amendment states that the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. So this basically means that the founders, when they were writing the Bill of Rights into the United States Constitution, they realized that there might be certain rights that they simply didn't think of, or they couldn't really quite agree on at the time. And they wanted these rights to be protected. But the problem was that, if you try and sit down and enumerate or list out all of the rights that you believe that should be protected, you might miss one. And if you miss one, then does that mean that the federal government is just free to violate that particular right? So that's really the argument that Justice Arthur Goldberg makes in his concurring opinion, that the right to privacy, although not explicitly mentioned by the Bill of Rights, should rather be enforced by the Ninth Amendment of the Constitution instead. And so Justice Goldberg is saying, hey, we're the court. We say that the Ninth Amendment allows for rights to be recognized and protected, even though they're not explicitly enumerated in the Bill of Rights. This seems like an excellent case for us to apply this amendment here. let's go ahead and do that. So that is basically the crux of Justice Arthur Goldberg's argument here, is that the 9th Amendment was designed for this very specific instance. All right, so this looks like a good place to leave off. So in our next episode, we are going to pick right back up with Justice Arthur Goldberg and his concurring opinion in Griswold versus Connecticut. If you want to learn more about this case, be sure to pick up a copy of my book, Abortion Division: Why Americans Disagree on Such Fundamental Issue of Rights, available on Amazon and Barnes & Noble. And if you like this video, please like and subscribe. Your support is very important right now, especially in these early phases of this YouTube channel. I greatly appreciate all of your guys' time, and I will see you soon. Thank you. Oh, and I almost forgot. Let me know what you think in the comments.